for joining us. I'm Beverly Carter, and today we're going to be talking about cohabitation agreements with our family law lawyer, Laurel Dietz.
Hi.
Laurel's there on the screen, so you should be able to see her. Just a bit about me. I've been commissioned as a notary for just over 7 years. I have a master's degree in applied legal studies from SFU. I have previous experience, which all lead to those 3 PhDs in life. So I find that's a really great help for my clients on a day-to-day basis. I have a very practical take on living generally. Housekeeping items. So we are doing a Facebook Live, but in this session, please do use the chat option throughout. And if you find this valuable, please share it with your friends and family on any community Facebooks or anywhere else that you know. Just a little letting you know that next week we're going to be doing another Zoom and Learn about pets in your will. We have both Thursday at 4 and Friday at 10. Today's topics are going to cover a whole bunch of things like what is a cohabitation agreement, general cohabitation agreement versus a prenuptial, why do people get them, common scenarios, what happens without a cohabitation agreement, who should have one, deciding whether or not it's appropriate. I guess that's sort of the same thing. You know, maybe general legal and formal requirements of a cohabitation agreement, how to prepare for getting one. And Laurel's going to definitely talk us through. So I'm just going to give a bit of a talk about Laurel. She's a Victoria-based lawyer. I met Laurel in the Chamber of Commerce about 7 years ago. And one of the things that I have come to know is that she's become a very trusted industry colleague for me and a friend. And I make a point of keeping up to date with her because very frequently I see people who are needing family law needs through my practice. And I have referred hundreds of people over to her. The other thing that I really appreciate about Laurel is that, and I think why I was attracted to her as another business person, is that she's ahead of the curve. So what everybody is doing now, Zooming and all that stuff, Laurel was doing 5 or 6 years ago. And she really has a unique niche perspective on helping people through what they call unbundled services. And she's bright, she's practical, and she's a new mom. So welcome, Laurel. So,
thank you, Beverly. I can't believe it's true. It was 7 years ago that we met. I'm just like a little taken aback by that. Oh, right. Wow.
Where does the time go? And your life has changed a lot in that time.
Mm-hmm.
And, mine too. And so, yeah, no, it's really nice. I really appreciate, you know, any advice that you've given me, or I get a tremendous amount of feedback from my clients who've used you, who are really appreciative of your style of offering legal services. So
that's good to hear. Yeah.
Yeah. Yeah, because you're dealing with often divorce and separation, and that's not always the most pleasant
no.
episode for a lot of people, right?
It isn't, but it is a period of time where there's a lot of self-reflection and growth, and it can turn into something that's very positive for people.
Yeah.
If they do it the right way. It can also go down the wrong path and turn into a very, very negative, bitter experience. So that's what we try to work with our clients to support them to make the good decisions and do that hard work, even if it's not necessarily legal work, but that deep self-reflection and making good decisions.
Right. Yeah, and that sort of leads into the reason why I wanted to talk about the cohabitation agreements, is because on the one end, you're looking at divorce and separation, and if people haven't sort of prepared for that, what are the statistics for? I mean, divorce is one thing, right? Because that's when you have a legal marriage. But then you have all these people in common law situations who just separate. And so the statistics of divorce don't really reflect the amount of breakups of spousal couples, right?
That's true. I never really thought about it like that, because they say 50% of all marriages end in divorce, but they would have no idea how many, common law relationships break down. after a period of time. And they wouldn't even be able to tell that, I guess, from tax documents necessarily, because for tax purposes, you're in a marriage-like relationship for a year, then you're common law for tax reasons. But for the family law, you have to be living together for 2 years. But there's no way to measure, how many of these relationships break down. Having said that, though, even when they do break down, they're very much like a divorce and separation. Like, we're doing the same separation work with common law spouses as we are with married spouses.
Right.
So
So I'm just going to shift here. So I'm just going to give a bit of my perspective and why I think that they're important. And it's a bit of what we've just been talking about. One is that I see a lot of people at different parts of their life doing different activities. So my tagline is for life's notable moments. So buying a house, having a baby, separation, divorce. I mean, I see documents and people making changes for all different reasons. So as a notary, I have a really interesting insight into the trends and grooves of people's lives and society in general, right? Yeah. So I also, have come to think that, societal attitudes have changed around marriage, of course, the traditional marriage, becoming a spouse is actually pretty easy. And I find even it's very casual, where a lot of people don't really give much attention to how easy it is. So you've said in the Family Law Act, it's 2 years. For income tax purposes, it's 1 year. And from my perspective, under the Wills, Estates and Succession Act, it's also 2 years. And so when I'm dealing with people, like, for example, for wills, I'm looking at the end of a relationship from the perspective of death, right? So a cohabitation agreement isn't always about a nasty breakup. It can end for other reasons, right? So I do review a lot of cohabitation agreements, and I can tell you they're not all the same. They've been done either do it yourself. Different lawyers have different templates and styles, and I was going to say knowledge and wisdom, right? That impact how they do their documents. And then the other thing is, the context. When I'm talking in terms of wills, I'm talking about the context of a person's life. And in some cases, I will identify to people, did you know that these actually exist, right? And I find anytime that I'm talking to a room full of people, this is probably the topic, the cohabitation agreements, that captures the most interest, the most questions, because everybody understands how that can relate to their own life, right? So when I'm talking about real estate, I might be seeing a young couple who's buying their first condo together. They may or may not have been together that long. I did one recently, and they've been together for 6 months, maybe dating before that. Sometimes it's the first time they're moving in together. So, or in some cases they're selling a property and it's a nasty breakup. So there's the other end of that as well, from my perspective in real estate. And then I'm going to say I probably, easily up to half a dozen people a week that we refer over to you. Whether or not they contact you is one thing, but I see through the notarization part of my business, people who are coming in and they've done it themselves and they're like, oh, I just need a witness. And I'm like, this is family law. I am not touching this. Because there is nothing in my insurance that allows me to be covered to give any family law advice. So that's why we have such a good relationship. And I have, there is another lawyer I do also refer to in the family law area. But just depending on what their needs are, you tend to meet most of the people's needs. They're quite happy to talk to you. But yeah, so we just unfortunately have to turn people down when we see that. So
yeah, and I know people are always confused by that. They don't really understand why can't you just get this notarized? And then they come to me often if they have these agreements that they've done themselves and they just want me to notarize them. And I say, like, look, we've got to sit down and either give you the advice. And generally the advice, if you've done your own agreement, is don't sign the agreement or don't don't proceed on this basis. Like, let's do this properly, because it will cost you thousands and thousands of dollars to fix a bad agreement, or deal with the fallout from a bad agreement, something that's not specific enough, something that isn't written in the proper legal language to deal with your situation. Or maybe you put something into the document that you don't really know what it means, and it means something completely different from what you intended.
That's true in any law, I find. Yeah.
Well, exactly. So it's any agreement, whether separation agreement, cohabitation agreement, is really important to have it properly drafted. And, you know, when lawyers are drafting these agreements, putting together their templates, they're doing so with, and it's the same with wills, with knowledge of kind of the case law of how these agreements are interpreted. And so, and also the knowledge of, like, we know where these situations go if they go bad, and we want to make sure we protect the client the entire time. And I just wanted to touch on something you said, Beverly, there, but how easy it is to kind of slip into a marriage-like relationship and not even realize it. So, you know, when you buy a house with someone or you put them on title, that's a moment where you might say, oh, wait a second, what's the legal significance of this? But if you already own your house, you have no intention of putting the other person on title, but you live together for 2 years, you keep everything financially separate, well, that's too bad. At the end of the relationship, even though you kept things separate, you're still going to be falling under the current family law if you've lived together for more than 2 years. And what the family law says could surprise you, because they're not treating what's hers is hers and what's his is his, or whatever. There's a very specific scheme of how things are going to be divided up. And so if you don't want to fall under that scheme, then you need a cohabitation agreement. And I think the same goes with the Wills Estate Succession Act. It's not my area. You can speak to that, Beverly. But, you know, if one of you were to die and your intention was, well, I'm not going to leave my estate to my spouse. I want to leave it to my kids, or, you know, my nieces, my nephews, someone else. You might be surprised about how the law will treat that.
Exactly, that's right. And that's where the getting the legal professional advice will save you in the end. Like, a lot of people will try to save money by either doing it themselves or just ignoring it. And honestly, you know, there's a range of costs I would get for this, but I would say, even if it costs $2,000 or $3,000, I would say it would be worth every penny, because it's going to cost you a lot more in anguish, grief, and financially, probably, right?
Maybe not you, maybe it would be your family members.
Or family members, right? Yeah, that's right. So let's just talk about some of the, just can you clarify a cohabitation agreement versus a prenuptial agreement?
Well, cohabitation agreement is what we call, prenup, cohabitation, marriage agreement. These are all sort of different names for the same thing. So the legalese right now is cohabitation agreement. That's what we call an agreement that is made either during the course of your relationship with someone while you're living with them, or if it's made before you move in together. And the whole concept is that it sort of sets out how you're going to govern your financial affairs during your relationship, after your relationship, and perhaps after your death, if that's what happens. So I think prenuptial is sort of an Americanism that we've adopted, sort of like attorney and alimony are things that we know what they are because we watch a lot of American TV. But it's not it's not the language that we use in our legal system here.
Right. I do feel that a prenuptial is people will react differently if you use that term versus cohabitation agreement. So, yeah.
It's interesting, I guess. It's a loaded term because it usually means you're cutting me out of all the assets and stuff before we even start our relationship, and you already don't trust me.
That's right. Yeah. But cohabitation agreement, I tell you, I get interest from younger people, from grandparents, from parents who all have a different take on this, and it's about life changes, right? So if your kid is moving in with somebody and buying a condo, you probably want them to consider this as an option, right? Or if you are widowed or divorced or long separated and entering into a new relationship, you might be interested in it for yourself because, you know, if you're 50 or 60 or even 70, you have your own, you've had a whole life before coming together with a new person. So we'll, you know, that would be a reason that people are quite interested. And grandparents who may be gifting, I had a chat just earlier this week with somebody who was like, yeah, I should talk to my grandchild, because they were selling a property and gifting 200,000 to a couple of their grandchildren.
Mm-hmm.
And I said, are you aware of these things? Because they didn't really think the relationship was all that strong. So, well, they should talk to a family law lawyer. So, yeah.
It's so I mean, I think anybody entering into a serious relationship, so one where you're going to start to live together, should stop for a moment and think, is this something that I need to do? Generally what I find is the only people who really need it, or who should really be considering it, are people who have either assets going into a relationship, you know, that they don't necessarily, that they want to identify are their own assets and they want to protect in some way. Or, you know, or where they might be receiving large inheritances or gifts from parents or third parties, we'll say. Those are like, once you start to hit that threshold where you have some assets, or then that's an area, I mean, where you would probably want an agreement. I mean, you also, the other situations you might want to consider looking at, you know, having a hard look at your partner's finances and think, okay, you know, they're a bit of a spender. I don't want to have to be responsible for their debt. I love them. I love the fact they're a flawed human being. But I also, if we break up, I don't want to pay them spousal support and I don't want to pay off their debts. So that might be another reason. If you don't have assets, you just have an income you want to protect, or a good debt-free life.
Well, yeah, I mean, there's all kinds of things. I mean, you work in the government, you get a pension, or teacher, whatever you are. I mean, there's all kinds of assets.
Yeah, people forget about their pensions as being assets. Those tend to be their largest asset, and quite a big thing to divide, depending how long you're with someone.
Right.
So you have this question here, Beverly. I thought maybe, why do people get them? Why don't we identify, or would it make sense if I kind of go through what the basic family law principles are if you don't get one?
Yeah, because that would spell out the negative consequences.
Now we can go through, these are situations that we see. And okay, so in family law, there's, on the financial piece, because that's what these cohabitation agreements tend to deal with, we're talking about property, so asset, debt, and pension division. So any asset that you acquire during the relationship, and that means from the date you start living together to the date that you separate. So it doesn't, even if you get married in there, it doesn't matter. It's the date you started living together to the date you separate. If there's an asset that's acquired during that time that exists on the date of separation, it's going to be divisible 50-50. So now let's say you come into a relationship with a house, you know, with, let's say, 100,000 of equity in a house. During the relationship, that grows to 600,000 in equity because the market's gone crazy, as we've seen in Victoria. And then you split up. The house has remained in your name, but $500,000 there is family property, because that was the growth during the relationship. Now you're going to have to, if you don't have a cohabitation agreement, your spouse is going to say, well, wait a second, I want you to buy me out, even though I've never contributed a cent towards the mortgage. I've never, you know, supported you in any way. You've worked hard, you've paid down the mortgage, you've been lucky that this has been an investment that has grown. Now I also get to benefit from that because you don't have a cohabitation agreement, and that's what the family law says. So for a lot of people, you know, who had housing that they purchased, you know, prior to 2008, or even now prior to 2016, they're seeing their assets have grown significantly in value to the point that they would not be able to purchase their spouse's interest without selling the house on their own. So that tends to be why people get cohabitation agreements. And so the other things that you're going to be protecting against in a cohabitation agreement would be spousal support, and then possibly not paying child support for stepchildren.
Oh, right. Yeah.
So spousal support is often one that people want to not be responsible for after the end of a relationship. If, you know, one person decides they don't want to work, they have a nice lifestyle, just living very simply, well, and you work hard and earn a big income, well, you know, you're supporting them, and that could be seen after the end of the relationship. You need to continue to do that. With the child support for stepchildren, if you are standing in the place of a parent to your partner's children, and you've supported them for a period of a year, then you could potentially have to pay child support for them after the end of the relationship, even if you have no intention of having an ongoing relationship with them.
Well, that's something I was aware of that, and I believe a lot of people are not aware of that when they're start entering into a blended family scenario.
Yeah. I
Yeah.
mean, so, I mean, I find a lot of people by that point, their children are grown, but not everyone, certainly. So it's something to be aware of.
Yeah, yeah, interesting. Yeah, because you know what that saying, an ounce of prevention is worth a pound of cure, right? I think some of our listeners will understand that one. So, is there, you know, how would a person prepare to do a cohabitation agreement, right? If you know, I mean, tell me what you think they should be doing.
Well, I think the first step is probably to have like a conversation with your partner and say, you know, look, I've got these assets, or there's this situation. And I think that, like, you know, we should talk about, what if our relationship were to end? How do we see this sorting itself out? You know, I'd like to be able to walk away with my house. And I think it's, you know, if you're going into a serious relationship, you should be able to have those conversations with your partner. And if you can't, maybe there's a problem. I'm not giving relationship advice, but it might be a situation where you want to seek some assistance to have those conversations.
Right.
If they're a sore point. And so that start there. And if you get the basic idea of what you want in a cohabitation agreement, how do you want things to be split up after you separate, then what you would do is you would approach a family lawyer, and we would get the first thing we always ask for is a list of your assets, a list of your debts, and approximate values for each thing. And then we're going to ask, okay, what do you want in your agreement? How do you want things to be? And most people have a good sense when they come to me for a cohabitation agreement. They're like, and generally it's always the same. I want what's mine to be mine. I want what's hers to be hers. No mixing. And so that's usually, we're able to do up an agreement quite easily with that. But some people have very specific ways they want to share property after the end of a relationship. So just being able to nail that down is start by having a conversation or giving it some thought, and then maybe approaching a lawyer for some advice.
So say a couple moves in together, and one maybe has 100,000, the other one doesn't, but then life changes for them. What happens if they get legally married? How would that impact it? Or what if they have children after the fact? Can they update this? Should they update it? Or like how?
Yeah,
life changes, right? Mm-hmm.
This is the advice I give absolutely everyone. It doesn't matter if you're 25 or 65 or 85. A cohabitation agreement is a living document. You need to be reviewing it every 2 to 3 years, even more than your will.
Oh yeah, right?
Because the thing is, life changes, life shifts. What might have been fair 3 years ago is no longer fair now. For example, the situation of children. So you had a cohabitation agreement going in. It says no spousal support will be paid. Well, 3 years later, we've got 2 kids and mom's staying at home full time. And then maybe 2 years after that, you break up and you say, well, wait a second, we have a cohabitation agreement that says you're not going to get spousal support. I can guarantee you the court is going to set that aside if mom is not able to take care of herself financially. So that's why you have to be, you know, you can't just say, well, we don't, under no circumstances, we don't want spousal support. You really have to have some thought as to what would be fair when we split up. And so in some circumstances, it's going to be much more fair to have spousal support payable. And so that's why you're going to want to be, it's better to be proactive and sort of say, these are the terms on which spousal support would be paid, rather than no spousal support at all, right? So spousal support is a really funny one, but having a look every 3 years, is your agreement still fair? And you're going to be comparing it to what would happen at law if that agreement wasn't there, and kind of how is each party going to take care of themselves after the end of the relationship.
Is primary residence, like province of primary residence, come into play in any of this?
I mean, I suppose with a parenting issue, you know, possibly, if that's what you mean with respect to parenting, it could potentially, if you were to identify, look, we're going to just do our parenting in BC, and then one of you wants to move back to Ontario with the kids.
So, well, no, but yeah, so say there isn't, say there's no kids, right? And they start out in BC and everything's fine. And then 3 years later, you know, Alberta's opened up again and everybody's working well and they've made that their primary residence. But in essence, the terms of that cohabitation agreement from BC would still work. And I'm thinking this as a foundational piece, right? To understanding,
yeah,
does that still apply?
So I mean, I've dealt with this in one issue. So generally, like an agreement will say with respect to, division of property and stuff, the law of, let's say the agreement says the law of British Columbia will apply. And that's what these agreements say.
Yes.
So let's say you split up, but you're in Alberta. If you wanted to apply the agreement, then you're going to be seeking to apply the British Columbia family law.
In my mind, it's just a foundational understanding that, new province, you should really revisit it. And because it may or may not apply in a way that makes sense. And there's possibly even a new situation, different work, more money.
And realistically, it's a practical nightmare because finding a lawyer, I mean, Alberta's you're going to find more lawyers in Alberta who can practice in both areas, but they're going to be fewer and farther between, right? You're not going to be able to go to any lawyer who's going to be quite as comfortable. They could figure it out, but you know what? I mean, I've practiced in the BC law for, I don't know how long now, 10 years. And it's just like, I understand it in a way that I could never understand the Alberta law if I just sat down and started studying it, right? It's, there's a lot of nuance.
They have the Power Act, which is something which I see quite frequently, because I'm doing oaths and I'm like, oh, that sounds so antiquated.
Mm-hmm.
Right? And a lot of law does come out of very old practices, right? When women were treated one way, men ruled the roost, right? And had all the stuff. So you can see how the terminology sometimes has got a very strong historical context, right?
Mm-hmm.
I'm just trying to get to, and so I had just come up with some different common questions that I've heard over time. Do you need a lawyer? And I would always argue yes. For these sorts of things, you bet, right? Don't try to do it yourself, right?
Yeah, I mean, that's what I would say. It never sounds as good coming from a lawyer because it sounds like we're very financially motivated, but the reality is we would be better off if you didn't use a lawyer because we'd be making much more money on the litigation side after
Fair point,
after the separation. So, like my motivation, and my main goal in practice is try to make people's legal problems as seamless as possible. Let's not get to the point where we have litigation. I'm not making more money off doing agreements than I would on litigation, I guarantee you.
Right.
But so use a lawyer, get it drafted properly, update it regularly.
That's right.
Keep an eye on it.
And then what could a divorce, what is the very minimum cost if a person needs to go through a divorce? What's the very minimum cost a person is generally looking at?
To go through a divorce? I mean,
you have to take it through the courts with a lawyer, right? So if there's some contested elements or it's just acrimonious.
Yeah, then you're looking at, if you're going through the court system with a lawyer, I mean, realistically, $50,000, it would not be unheard of.
Right.
Hopefully you could do it for less. I mean, even just doing a separation agreement where there's a lot of negotiation, you need lawyers involved, you're looking minimum $10,000.
Right.
I mean, that's the thing is like with the practice that I have, like we encourage people and we guide people through negotiating their own agreements. And so we try to keep it under $5,000. I mean, the drafting of the agreement itself is only $1,200, but it's the getting to the agreement is the hard part.
Well, and emotions run high in those times. So this is where I come in, and when I'm just giving some basic education to people about the fact that these exist, I said, the time to put something together is when everybody's happy and
Absolutely.
thinking clearly and not jockeying for position or hurt or whatever, or just trying to get
When
back.
people are feeling generous.
Yes. Yeah. And I mean, it's the same advice, it's the same information I provide. The time to do your will or any of your other legal documents are when you're clear-headed, not when you've just been given a diagnosis that you've got 3 weeks left to live, right?
Yeah.
Because you're not thinking in the same way. And so plan, I think it's fair to say plan that your relationship won't last. I once heard it said from a guy, know how you want things to end before they begin, or at the beginning, know how you will end it, right? And I thought that was a very sage piece of advice that I've used in my own thinking, different aspects, right? So in business particularly, but that was that context. So
I mean, I just want to, and just to say, I said at the lower end, going through court to a trial, like 50 grand would be a good price for a divorce. I should say that many people spend hundreds of thousands of dollars dealing with these issues, and it bankrupts people. It's not uncommon.
That's right. And they don't care. It's like it's a scorched earth policy, right? I have money sitting in a trust account because a couple have had an acrimonious divorce. They sold the property, but they did that under a different, the real estate contract, and they still can't agree that one lawyer should just hold the money. It doesn't give them more weight, it just it's
just one of those things. And you know what, Beverly, I can tell you, you have one client. I know many people who are in that situation.
Yes, right.
It is very common.
Yeah, I'm sure. Yes, I'm sure. So then there's the other part that I come across, where I find sometimes you'll have, I'm doing a real estate deal, and a parent and one of their adult kids are buying a house, and, one's living in the suite and the other one's living in the main house. What kind of an agreement applies to that? Because they're not married, they're not common law spouses. How would a person approach that kind of a agreement? Because, any idea?
So give me the background. Who's living in the suite?
Well, parents usually. So I'm seeing from time to time you'll have parents and kids going in on a property together. Sometimes they're all jointly owned, so joint is the right of survivorship. Sometimes they do a tenants in common, which is a share ownership, right? But in my take on it, sometimes there can be different expectations about who pays what. So maybe sometimes the parents go on as a 1% owner to guarantee the mortgage essentially, but they really live there and use half of the utilities and taxes, but they don't have the greater asset ownership.
As between the parents and the kids, you're wondering. So I think that would be more like a co-ownership agreement rather than a cohabitation agreement.
Right.
Because the cohabitation agreement sort of implies that it's sort of a marriage-like relationship. Right. So a co-ownership agreement in that case would be very important. But what would happen, the change there is when one of the kids partners and the partner moves in. Right. And then between the two of them, the parents are going to be pushing their child to say, you better get a cohabitation agreement because we don't want our housing to be compromised in the event you split up, and we can't afford to pay out your spouse. Right? That's where the real issue starts happening, and you start
as well, right? That right. Actually I had one a few weeks ago, and that exactly was the situation, right? So they had to sell the entire house because the two left standing couldn't afford it anymore because the one person wanted to get bought out. And I think this was kind of just, happened along with COVID. It was bad timing as well. So they ended up having to sell. And so, I always think about, in my world, it's about what the unintended consequences are, or what could happen if something falls apart, either through, I often look at it because of incapacity or death, but but there is, from your perspective, the death of a relationship. And that's where there are a lot of parallels in the way I think about things from my other perspectives as a notary to what you're doing. You obviously take it from the family law perspective, but I need to know about all of this in order to best service my clients. In some cases, I'm reviewing their documents to embed into, to refer to it like in a will. But sometimes it's have a power of attorney agreement. Don't make it your spouse who may have, if things go sideways, don't give them that power. Keep it at arm's length with somebody else, right, who doesn't have an emotional stake or, some other, undetermined interest. Yeah. So unfortunately, we have to think about the worst side of people in some cases in order to give the best advice. And it's not that they're bad people, but we do know situations fall apart for various reasons.
Absolutely. And I think, so then the other side of the end of a relationship is, as you say, when one party dies, right? So you're embedding these cohabitation agreements potentially into a will. So, and the reason for that is because the Wills, Estates, Succession Act says that you have a moral responsibility, or the law says you have a moral responsibility to provide for your spouse and your children on your death.
Right.
And so people can vary wills, and you might go into a relationship with someone, you have kids, they have kids, and you both want to make sure that, you've already had a divorce, you've lost half your assets, you've recovered yourself financially, and you want to be in a position where you can leave your children something after you die. But there's always the risk that you are the one who dies first. And then all your assets from your relationship, from your previous relationship that you've built up and rebuilt up over your life, could potentially go to your spouse, which is then going to go to their kids, not to your kids. And so that's always, especially in a blended family situation where you're wanting to have a cohabitation agreement or something, if you want to protect your assets for your own kids.
That most of my clients get when they're a blended family, because they just don't understand that when they create these joint bank accounts, when they buy the $1 million house jointly, regardless of whose money is put in, it depends who dies first. And so putting some thought into the financial structure of your assets when you're combining houses or combining yourself with another person, set it up for success, set it up for what your objectives are. But I'm just shocked at how many people really don't understand the nature of joint ownership until it's too late, right?
Well, and the interesting about the joint ownership is that a lot of those things won't pass by way of your will. They just automatically go to your spouse.
Right.
So,
right.
There's that you see that situation where it's like a second marriage, you have kids from your previous relationships, whatever, and then you put all your assets in joint names because you think, well, it just makes sense for either one of us to be able to deal with these things.
Yeah.
But then, you don't realize, but in your will, you say, I'm leaving everything to my kids, but you actually don't have anything to leave to them.
And that is so common. It is so common. But then at that point, they're too entrenched often in the relationship to want to, sever the tenancy to go a 50-50 or a 30-70, whatever. There are options out there, but one of the, I believe some of the people who are listening in today are either parents or grandparents. And, they're often in a position, and I commonly hear this from them, concerned about their kids' relationship and giving them money, stuff like that. How would a parent or a grandparent approach this topic with something that they're concerned about? Any tips?
Yes, and with a lot of care.
Yeah, right.
So this is a really interesting area. So under the Family Law Act, if you receive a gift from a third party or an inheritance, it's considered excluded property. So that means it's not subject to division on separation. Having said that, the growth in value of that property would be subject to division, right? So that could be a problem if there ends up, so I've dealt with a number of scenarios where dad wants to give an early inheritance to grown child who is in a marriage, right? So they buy them a house. Right. Then the relationship breaks down. Oh my gosh, the house has really grown in value. spouse has never contributed anything to it, but now we can't afford to, again, pay out the spouse's interest. So one way one way it was protected, and one way I've seen it protected is that dad went on the mortgage as a mortgager for the full amount of the gift. And so that protected at least the base amount, but it didn't protect the growth. And so it's always that growth which becomes the problem. The other issue is if you take if it's just a cash gift, let's say 300,000, and you put it into a jointly owned asset. What's going to happen is you've taken an excluded asset, but you put it into joint names. Now, what the law says is that we're going to presume that that is a gift.
Yes. Yeah.
Unless you're able to prove that was never the intention to gift it, right? And of course, you split up and the other spouse is going to say, wait a second, doesn't remain excluded property. That was a gift to me. Not obviously. A lot of people are very honest, not everyone. And in some situations it was a gift to both and not just a gift to one. But when you're dealing with large sums of money, it makes sense to go off to court and fight about it, right? Because hopefully it's going to cost you less to fight about it than what you would get at the end of the day. But so if you're protecting yourself at the front end, you're going to be very careful about taking any excluded asset, any asset that's a gift or an inheritance, and putting it into an asset in joint names. And if you do that, that's fine. You just need to do the paperwork to cover it off, right? So be very prudent about it. You're going to do either putting a mortgage on title, or you're going to be doing an agreement of some sort saying that my intention is not to gift you this money. My intention is to have this back if we end up splitting up. Yeah. We're just using this for the purchase of the house or whatever. So being very clear and documenting it, having that paper trail, because that's going to be the best evidence if you end up fighting about it later on.
Any trust agreements that they can put in place?
Well, I mean, I think just a cohabitation agreement is probably sufficient.
Right.
Or what you do is you keep the name, you do a cohabitation agreement, and you also keep the asset in one name.
Yeah.
Which, might not be okay with your spouse. It might be, look, we're trying to build a life together. We're both using, I'm contributing to this mortgage and the expenses, and I'm working hard. Why should I have to, lose out on the opportunity of an investment that I'm contributing to? And so it's just having those conversations. How are we going to split this up if we split up?
Yes, right. So do you have a sense of different generational attitudes towards assets, and is there?
Well, I think I don't know if it's necessarily generational. I think it's stage of life attitude.
Okay.
So when you're entering a serious relationship, when you're young, and you're getting married, or even if you're living together and having kids, but you have no assets, you don't have kids yet, but your intention is to have kids together, then you're going to be a little bit more open to saying I have no idea where life is going to take me. This is going to be a longer term relationship. I'm quite certain of it, or, and it makes sense to let the family law apply in that case. Where I'm seeing it, people who are wanting the cohabitation agreements are people who've been through divorce. They're older. They're not entering into relationships to build up assets together. They're not building a major life. They're enjoying each other's company. It's companionship, but they've made their money and they've built their wealth, and they're not wanting to share. They want to keep what's theirs is theirs. So that's where I find a lot of people come to me is really, it's the going into a second relationship. They're just protecting themselves because they want to protect what they've built up for their children.
Yes. And yes, that is most commonly those who do come to me who have the cohabitation agreements. That is very much the sentiment. And generally, it's always their second relationship, either widowed or divorced. And they just want to enjoy the love of each other, really, without complications. And I find that they're really often very pragmatic and very open people. And so they understand, they've thought it through, and it's always so lovely to see that, Well,
I think it's the basis. It's a basis for a healthier relationship.
Sure.
I would think, but
yeah. So.
Yes. I don't think that the statistics for keeping people together on their second marriages is any better than their first. So what do I know?
That's right. Yeah. So, well, I found this really fascinating. I mean, I love the topic, and I'm always striving to find ways to bring information to my clients, or to refer them to people who I know can help them. And so that's one of the reasons for having you here today. I wanted to just open this up to see if any of the people who are attending are interested to ask any questions. So I'm going to just do a Q&A, and I'll just leave it for a moment to see if it can take a moment for somebody to type things. So just open that up, or if any feedback would be great. But just so you know, we will be posting this on our YouTube, and showing it also through Facebook as a link. I do recommend, if you know somebody who would find this valuable information, I'm going to say probably most of us could find somebody, at least a few people who would benefit by at least knowing this. I always find if you learn about it now, somewhere down the road, you're going to remember that you've got information and that it may apply, right?
That's
and
right.
So you can help somebody else, whether it's a friend or family, or your own kids, or your own parent for that matter, or grandparent, for all we know. So I'm not seeing any questions popping up, but
we answered them all, Beverly.
yeah, well, but that's okay. There are a lot of questions that people didn't know they needed to ask or are afraid to ask. And, I've always found, another testimonial for you as to a reason why I find you a good and very trusted industry colleague is because there's the ability to talk to you. You're not in some great mahogany lined wall office,
As you can see.
Yeah, there's a baby back there somewhere probably.
Yeah, she's squealing. I can hear her.
yeah. So it's, I think it's being really approachable, and it's certainly a style that I have in my practice, that people just need. They're scared to talk to somebody because they don't, they don't want to appear to be not knowing something. But if you open the door for them to feel comfortable to ask the questions, that is one of the things that I've always found with you. It's my style. I probably gravitate to people who I feel can, who are good that way, right?
Well, and that's what I find as a foundation of my practice is, like, I want to teach people, and not just do things for them. I want to teach them and explain the reasoning behind things and why things are a certain way so that they can better approach any matter in the future, right? So if you have that understanding of why things are a certain way, then it's easier for when you encounter a similar problem in the future.
Exactly, right? Yeah, and that's what I find. You empower people with education, factual information, based on what you know about the law, but also about the application of that, because that's a whole other story. And many of us just hear about the negative consequences of relationships not working out. And I would rather see that we build up people to be successful, and also be, aware that if and when they do end, whether it's from death or disaster or other things, that they've got a tool that will lead them through and keep intact more. Oh, I do see a question here, so gotta find it. I see it popped up.
Yeah.
So this is, I may not have heard, but have you already gone over the process to get one done? Can a notary do one, or just a lawyer? And what's the average cost? So I'm going to say for sure a notary does not do them. A notary does not witness them either. So when you're doing them, it has to be a lawyer. But I'll let you speak to the process.
Yeah, so I mean, I'll speak to the process at my office. So what we do is we can only work with one party. That's the important thing. We don't work with both. So what we do is we do our intake with one person. We go through your basic rights and responsibilities as if the cohabitation agreement didn't apply. Then we talk about what you want in your cohabitation agreement. So what we had talked about was it's important to have that conversation with your partner before you come into our office. So, I mean, or at some point shortly thereafter to discuss what you want. And then you're going to, provide us with a list of your assets, debts, assets and debts so that we can put that into the agreement, and we'll get your instructions. We draft the agreement, and we provide it to you. Your spouse partner gets to go take the agreement to their own lawyer, get advice on it and whether or not they, want any changes. And then when both of you are happy with it, you both sign it and get your certificate of independent legal advice. Both spouses getting their own independent legal advice is a very important part of the process. People like to skip out on the extra $250 or $500, whatever it is, to do that. But that is the thing that is the belt and suspenders that's going to make sure that this agreement stands the test of time. So average cost, we charge for all our agreements, we charge $1,200 plus tax for just the drafting of the agreement and that intake process. So if you want negotiation on your behalf, there's add-ons. But most people can keep it at the $1,200. If you go to, I would say most lawyers in town, you're looking at that at least $1,200, anywhere from $1,200 to about $2,500 to have one of these drafted. And then of course, with the independent legal advice from another lawyer, there will be additional costs for that. So ideally, the whole process and cost would cost you, $2,000 or $3,000 at most at the end of the day, depending on the lawyer you choose.
There's sort of a parallel in my intake process. There's basic information you just need to know about people. So they're the parties involved, their names, full legal names, address, date of birth, if there's any kids, list of assets, lists of debts. And for years, I've always told people, if you're seeing a lawyer, the better prepared you are, the less you're going to get charged. Because if you go in there unprepared, knowing nothing, they're gonna ask you to do all of that, and it's going to spend more time for you to have to go back and review things. But if you come in with a nice handy list of this basic information, then they'll go and they'll fill in the blanks, and they'll ask and they'll get the questions depending on your particular context, right? So
yeah, that's true.
Yeah.
What was I going to say just about that is, the other thing is it doesn't happen overnight. This is a process. It can take, I would say, 2 to 3 months to really get it nailed down.
Okay. Mm-hmm. Yeah, that's all. Oh, that's good to know, right? So, and what if this is one thing I often will see is there where one of the parties often initiates this, the other person isn't as keen to do it, or they don't want to get independent legal advice. Do they waive it? I mean, I know it's not recommended, and that can come back.
You can waive it. And again, strongly not recommended, especially for cohabitation agreements. Separation agreements, we don't recommend it, but a lot of people do waive their independent legal advice. But for a cohabitation agreement, right, we're dealing with a situation. Separation agreements, we know what the situation is. It's already all in the past. Cohabitation agreements is going forward. If people are going to be waiving their rights to certain things, you want to make sure they know what they're waiving.
Exactly. Yeah. Cool. Well, that's been awesome. I really appreciate your time. And
thanks for having me.
Yeah, I'm not seeing any other questions, but I'm hoping that we have answered that one fully. It seems like we have. So I just want to thank Laurel very much. Again, I truly value the friendship and your and I thank everybody for coming aboard to listen. Here's some contact information. If you have any other things, you can follow up with Laurel. You can go to her website. And just to remind you that we're going to do a session next week. We're going to have 2 of the same session, and it's called Pets in Your Will, which should be fun. And I might even bring my dog. So anyhow, thanks so much. And I'm going to say farewell to everyone. Thank you.
All right. Thank you.
Okay. Bye.